Welcome to the Ottawa Business Journal's live broadcast of the do's and don'ts of electronic monitoring of employees. I'm Michael Curran from the Ottawa Business Journal. I want to thank you very much for being with us here today. We've got hundreds of people tuning in on YouTube, on LinkedIn, on Facebook and Twitter. As always, we want to make today's show as interactive as possible. We will be turning to you, the audience, the live audience, for questions. You can input those questions through any type of social media outlet or platform that you're watching us on. We have got a really intriguing topic for you, and I think it's something that's on the minds of both business owners, managers, and employees. The issue at hand is the electronic monitoring of employees, and more specifically, what are the obligations of employers? Electronic monitoring, of course, isn't new. In the past, we've had things like video, audio surveillance, even GPS tracking. But what's changed a little bit in the past few years, of course, is that fewer employers are going to the office. And that means some employers are considering the electronic monitoring of employees, something like keystroke monitoring, for example. So not only is it topical, but there is a legislative reason why you need to understand this topic at a deeper level. In the province of Ontario, we have Bill 88, which is the Working for Workers Act 2022, and it will require employers with more than 25 employees to have a written policy in place and shared for electronic monitoring. And the deadline is almost here. You'll hear about that in a second. So as you can appreciate, this is very topical. It's very kind of a post-pandemic subject, and we're very eager to explore it with our two guests. Why don't we meet them right now? So our first guest is Raquel Chisholm, partner at Eamon Harnden. Welcome, Raquel.
Hi, thanks for having me.
There she is. I'm so happy you joined us. I know you've got lots of information to share. I'm going to welcome your colleague. Our second guest is Negin Yazdani, a leader Eamon Harnden. Welcome, Negin.
Hi, Michael. Thanks so much for having us.
It's great to have both of you with us. And Raquel, we're going to set the context a little bit as we ease our way into this topic. This is something you're starting to hear from employers, your clients, at Eamon Harnden. Tell us a little bit about that.
Yeah, well, whenever the government requires employers to create new policies, we hear from our clients about helping them to create the new policies. So this is no different. There's a deadline of October 11th for employers to have electronic monitoring policies under certain circumstances. Not every employer in Ontario has to follow this legislation and this requirement, but many do. And so, yeah, we're certainly hearing from them about scrambling to try to meet that deadline.
And Negin, we just heard there's a deadline coming up. It's in early, mid-October, however you want to position that. It is something that employers need to wrap their heads around right now. So the time is now for people to be hearing more about this.
Absolutely, Michael. You know, summer feels like it was just around the corner, but if you look at the date, it's, almost the end of September. And so October is just around the corner, and this webinar comes at a great time given that October 11 deadline.
And as always, the format that we're going to adapt today is some quick segments, about 3 to 5 minutes. And we're going to look right now at the agenda so people know what to expect from the live broadcast. So the first thing we're going to look at is, what does electronic monitoring mean? So let's define what we're talking about here. Next, we're going to say what's needed in a policy. So we're going to talk about that. Also, what else do employers need to know? There are some related issues you need to consider. What a policy will mean on a day-to-day basis. And then, of course, we've seen so many changes in employment law. We need our employers to remain up to date. And then after we tackle those 5, I guess it is, 5 sections, we're going to end off, as I was mentioning, with a Q&A with our live audience. So again, I'll be calling out for your questions. You don't have to wait to the end of the show. I'll be looking for them throughout the show. So please input them in the next few minutes. I'm sure as we get into the topic, it's going to twig all sorts of interesting questions. So let's dive right into this, Raquel. You're going to help us define in topic number 1, what electronic monitoring means. Over to you.
Sure. So the legislation, the new legislation and the policies that are coming out from the Ministry of Labor don't actually define it. So there's nothing that we can read a definition of in that legislation. Instead, what they say is electronic monitoring is any monitoring that you do of employees that's electronic. So that's sort of a sky's the limit type of definition, right? So really we need to talk about examples. So for example, if you have key fobs or any sort of electronic system when employees come into a building and you track what time they come in, what time they leave, etc. That would be electronic monitoring. It's essentially anything that's not with your own eyeballs. So GPS on trucks, are you monitoring that? Are you monitoring how quickly your cashiers scan things at the grocery store? Are you monitoring people's use of the Wi-Fi and the bandwidth in your workplace? Anything where you're sort of gathering electronic data about your employees, that would be considered electronic monitoring. And the one thing I would say to employers is, if you're in an HR manager type role and you're putting this policy together, you need to talk to your IT people because you may not know what you're monitoring. And maybe your IT people can give you a list of here's all the things that our software and our servers are doing automatically because we didn't set a default differently, and this is what we're tracking. And that conversation needs to happen at kind of a team level to figure out all the things that the employer is monitoring. Because I would be really surprised if most employers wouldn't be surprised about what they're monitoring.
As you're talking about this, it's really crystallizing in my head. I would have never thought of a key fob, but of course, that information's recorded. Logging onto a computer would be another example. So I was kind of thinking olden days, video, audio, GPS, but you're right. Even the managers and the business owners themselves might not be aware of what's being tracked. Such a good point, Raquel, to go to your IT department and say, let's think through this carefully. So that's a great start. We have a sense that many more things are included than certainly I would have considered. Negin, we're going to go to you for topic number 2. What do employers need to include in their written policy? So we understand what electronic monitoring might be. We know we need a policy. What's included?
Yeah, sure, Michael. So first of all, this policy can either be a standalone document or it can be included within a collection of policies and procedures that the employer already has. And I'll cover what the policy must include. So first, you must include a statement as to whether you do engage in electronic monitoring of employees. And as Raquel presented to us just right now, it's quite broad. So the Employment Standards Act does not define it, but we know it really covers any monitoring that's done electronically. So we would recommend, again, that employers become fully informed and engage the right experts before coming to a determination as to whether they do electronically monitor. So if they do not, after becoming fully informed, the policy must specifically state that they do not electronically monitor employees. And then that would be the end for those employers. However, if employers do engage in electronic monitoring, they'll have to include a description of how they do monitor their employees. So for example, it would be key fobs, GPS on vehicles or cell phones or videos. The list is kind of endless. So really reflect on what practices you're doing. Next, you'll have to include a description of the circumstances in which you would monitor your employees. So this could be at all times. This could be if there's a policy breach and you want to investigate. Just specify kind of what circumstances you might be monitoring your employees. And then lastly, you'll have to include the purposes for which the information obtained through electronic monitoring may be used by the employer. So this could be, for example, for disciplinary purposes, to track employees' time spent on certain tasks for compensation, or to ensure that employees are complying with workplace policies. And we would highlight that while these purposes are included in the policy, employers are not limited to just those purposes. So for example, if you want to use some of the data you collect to investigate an incident, but this purpose wasn't listed in your policy, you're not limited from doing that if it does come up in the future. But again, we would invite everyone to reflect on what purposes they may, and what purposes, what circumstances, and how they may electronically monitor their employees.
Okay, excellent. Please keep going.
Just lastly, the smallest piece is just including a date. You have to include a date that the policy was created, and then any date that you make changes to the policy as well. So that's, in a nutshell, what has to be included in the policy.
That was excellent. So there's a bit of decision tree. No, you can stop. Yes. Right. And then it's how, and then it's what purpose. And that was a really good point too on the what purpose, that it's doesn't have to be too restrictive, and then the date that it was implemented. Okay. Right. Those are some of the key ingredients. Nagin, we're going to stay with you in the next one. I think there's some related issues. So what else do employers need to know about the policy requirements?
Right. So who does this apply to? I think that's something that we all want to know. Employers that employed 25 or more employees on January 1st of this past year, so 2022, they will need to have a written policy in place with respect to electronic monitoring by October 11th, 2022. So just in a couple of weeks. And then going forward in 2023 and beyond, any employers who have 25 or more employees as of January 1st of that year, they must have the policy in place by March 1st of that year. So we have that immediate deadline in October for this year. And then again, next year and the years that follow, March 1st is the key deadline to keep in mind. So if you don't have 25 or more employees on January 1st, but then later in the year you do, you're not captured under this requirement. We're only looking at January 1st of each year. And if you have 25 or more employees, then you're captured and you'd need to have a written policy. So employers will have to provide a copy of the policy to employees within 30 days of the deadline to have a policy in place, or within 30 days of making any changes to the policy. For new employees, you'll have to provide them a copy of the policy within 30 days of them becoming an employee, or within 30 days of being required to have the policy in place, whichever one is later. And then again, for assignment employees, so this would apply to temporary help agencies, you'd have to provide a copy of the policy to them within 24 hours of the start of their assignment, or within 30 days of having to have the policy in place, whichever one is later again. And then how do you provide the policy to them? There are a number of options, but the key piece to keep in mind is that it must be printable by the employee. So you can go ahead and provide them a printed copy, or you can send them a link or an attachment. And as long as the employee reasonably has access to it and can print the document, then that's fine. And employers must retain a copy of the policy for 3 years after it is no longer in effect. So this is an important piece to keep in mind. I think it's constantly going to be updated. We know that as practices change, and but again, you'll have to hold on to those policies for at least 3 years. And then lastly, something else that employers should know is that different policies can apply to different groups of employees. So while the policy must cover all employees of the employer in Ontario, this doesn't mean that employers will need to have the same policy in place. So for example, a retail business might want to have a different policy in place for their sales staff than maybe they do for their employees in head office, for example. I think how they might electronically monitor and in what circumstances, they might differ between the two groups. And so we'd really invite employers to reflect on any different groups of employees they have and make sure that the policy really targets that group of employees.
Wow. A lot of details there. Very practical stuff, by the way. So January 1st is kind of the measurement point, and then you're looking in future years. I got the printable thing. I thought it was an interesting point as well, just reiterating what you said there, that you might have a team of people in a warehouse or on the sales floor, and then someone in finance, for example, and you might have differing rules for different people. Just thinking of warehousing these days, things are being monitored, inventory levels electronically through sensors and that. So wow, that's a lot to take in. Thanks, Nagin. Yeah, Raquel, I think we're going to come back to you on topic number 4. There's a lot to digest. And by the way, I should just point out we have lots of questions coming in, and we'll be getting to your questions in just a few minutes. Continue asking them, and we'll be taking them as much in order as we can. But let's get back to Raquel. So on a day-to-day operational perspective, Raquel, what will this policy mean for businesses?
So it actually doesn't change anything, I would say, on a day-to-day basis. I mean, you have to put the policy in place. You have to keep in mind those deadlines. But it doesn't, the requirement for this policy doesn't create a new right for employees to now say, oh, you monitor me for this, that, and the other thing. I don't want you doing that anymore. It doesn't create that kind of veto right for employees. And so that's not changing. You can monitor what you can you're continue to be allowed to monitor things that you were allowed to do before October 11th, after October 11th. However, this policy requirement doesn't prevent employees to exercise rights they've already had. So some employees have rights already, privacy rights already, regardless of this policy coming into place. And so, for example, unionized employees under the collective agreements, there's been lots of litigation about video surveillance, GPS tracking, a lot of that kind of electronic monitoring. And there's a whole slew of jurisprudence from labor arbitrators about when an employer can monitor, what they can use it for, and so on. So those rights already exist. What this policy is going to do is to highlight now for employees, this is how we're monitoring you, and maybe unions will be very interested to get that information, and maybe there will be more grievances. So that might impact your day-to-day operations. But there's no new rights for employees. And so employees have always had the right to sue employers for egregious breaches of their privacy rights, either in the courts as part of a termination litigation, or there's something called the tort of intrusion to seclusion, which people have gone to the courts to say that their privacy rights have been breached. And so there's always, as long as it can meet the test, which is a pretty high bar, employees have that right. So from that perspective, things have not changed. Employees will have the right to go to the Ministry of Labor and complain if they weren't given a policy, but that's it. That's the only right they have, to complain to the ministry. They can't go to the ministry and say, I got my policy, but I'm not happy with what's in it. The ministry is not going to listen to that. All the ministry wants is, were you given a copy and were you able to print it? And they're going to be satisfied. So in that respect, it's not going to change things. Other than you may have a lot of employees who are going to read that policy and be shell-shocked and say, what? And so from a management of feelings in the workplace, this is going to maybe cause some consternation. So employers should be ready to sort of assuage fears and will want to draft their policies in a way where those how we monitor and why we monitor is really clearly defined, so people don't aren't overly upset when they read all the various ways that they're being electronically monitored.
Some really important points there, Raquel. Oh my goodness, let's just start with the last point you made there. So yeah, there might not be an employment law issue, but there could be a management issue, right? As you disclose as a company, here's all the ways you're being monitored. And again, as we talked about before earlier in the show, we probably don't all of us, we don't realize, all the different things from I'm not even talking about the keystroke type stuff. I just mean when you logged in, when you logged out, when you swipe to come into the office, when you swipe to left the office.
Yeah, I didn't know you could measure that I was downloading movies on your Wi-Fi.
Wow. Yes.
Right?
Yeah.
Who knows?
Yeah. But the other thing you said that was really interesting, just to touch on it again and underline it, is so the requirement, of course, is for a policy, and the policy doesn't require agreement from the employees because it doesn't give them any new rights, as you said. But it also doesn't negate. I think I heard you clearly, the privacy rights that have been decided in legal decisions in the past. Whoa.
That's right.
Okay. This is really interesting. And we're doing really well on time. So, but we've got a fifth topic that we're going to, Raquel, you're going to wrap up with us, and then we're going to go to our Q&A. So I see there's lots of people waiting. We're going to get to you in a second. And that fifth topic is, how can employers ensure they remain up to date? We've talked about a ton of details here, and there's a risk, I guess, that employers could get out of date. So what is your recommendation, Raquel?
So probably the first thing is to you have touch tones every year, and January 1st you have to count how many employees you have to see if the policy still applies, and then in March 1st you have to have the policy in place. So between January and March, that's your time to sort of update your own knowledge about, are we monitoring something new? As Negin said, there might be a use that comes up the previous year that you didn't contemplate, but you ended up having to use that data for something you hadn't put in your policy. So you can update your own policy just by, again, circling back with everyone to see whether or not there's anything new in your workplace. So that's probably the first thing, is to just have, it's electronic policing week kind of thing in January, or what have you, between January and March to update it, and just update things all along. You have a new kind of software, it should be ingrained now to ask, does it do any electronic monitoring of employees, that software? Do we need to do it? Can we turn off that default? You have to have those conversations on an ongoing basis. The Ministry of Labor has a pretty good guide on their own website for Employment Standards Act requirements. And so, you can often go in there and read to see if there's anything new in the regulations or the policies. Our firm puts out focus alerts, they're called. So anytime there is a change to legislation or regulations or policies from the Ministry of Labor, we put those out so you can get on our list if you want to receive those updates. And then also, employers, if they have sort of check-ins with their labor and employment lawyers, they can get legal advice on anything new that's coming around. But those would be the things I would recommend in terms of keeping up to date.
Okay, good. I like your suggestion there about putting something in your calendar each year. Just it's electronic policy week. What do we need to update? Second thing you said, though, is this is going to have to be like a team effort, particularly with the IT department, I suspect, because managers will need to educate the IT department to scrutinize any sort of new technology that's coming into a workplace, and say, please think carefully about, how people are being tracked, because we've got a requirement to disclose that.
Yeah, for sure.
Okay, so listen, we have a bunch of questions, and I always appreciate the fact that we've got two experts here, and we're throwing fastballs at them here. So, they may or may not, Negin and Raquel, have the answers to it, but we'll see. And there's a bunch of questions, so maybe we'll try to keep our answers, if reasonable, to about 30 seconds or a minute. And I think we've touched on some of this, but sometimes people just need to hear, it kind of reiterated. So the first question is from Jeremy Lamarche. And Jeremy is asking, again, who is exempted from having to implement this policy? And he's talking about, like, if you're an employer with more than 25 employees, is someone exempted? And sorry, Raquel, I'll go back and forth with you and Nagin on this. So Raquel, if you want to start that one off, if it makes sense to you, go ahead.
So very few people are exempted, very few employers. It's really like the core public service of Ontario, the crown essentially is exempted. But if you're in the private sector and you have 25 plus employees on January 1, you're in. You have to do it.
So I think there's an assumption there that, again, unless you're part of a Crown Corp or something like that, you better assume you're in and take some action.
Yeah.
Jessica Martineau, and maybe we'll go to you on this one, Nagin. I think some of these are just like a confirmation of what you've said. So this includes, so I presume Jessica's asking here about, what to include. This includes what we are unknowingly electronically monitoring. And this gets into the whole IT question that we've been talking throughout, Nagin. So it would include, I presume, what unknowing electronic monitoring is happening.
Right. The purpose of these policies are really to provide transparency to employees of what's kind of going on behind the scenes. And so that's why we really invite employers and recommend that they do know what's going on and engage the right people to figure out what is going on, how are employees being electronically monitored. And so that way you can really include a fulsome description in your policies. Okay,
the good answer there. The next question comes from a YouTube viewer, Gabe Depuis Jalon. Hope I got that right, Gabe. And here comes the question. And again, I think some of this is just a validation of what you said before. Can we assume that we'll need to include and specify active versus passive tracking? And he's making a point here. Many orgs don't review key fob logs daily, if at all, unless there's been an incident. So maybe, Raquel, can we assume that we'll need to include and specify active versus passive tracking?
Yes, absolutely. And that's where the policy sort of has those sort of three things you need to include: what you monitor, how you monitor it. So it's daily, somebody's checking those logs every day versus we don't check them unless there's an incident, right? And then what you might use that for. And so you're right, in terms of the fob thing, unless there's an issue with somebody's tardiness, you may never look at those. Or if there's an incident, you need to know who was in the building at the time. You may not, other than that, you may not look at it. So it is that, I like how he framed that, actually, active and passive. It's both.
Okay, really interesting. So next up for you, Nagin, from Anita Stafford, who's joining us on YouTube. Anita is asking, and again, I think it's a confirmation or validation of what you said. Would cameras be included in the workplace? Sorry, would cameras installed in the workplace need to be included in the policy?
Absolutely.
Yes. Yes. I'd echo Raquel that, video cameras would fall under that broad definition of electronic monitoring. And so, that's for sure something that would have to be captured in the policy.
Okay.
Many employers already have policies for video surveillance. And so it would be a matter of sort of either merging those or cross-referencing those.
Interesting.
Yeah.
Okay, that's good. Raquel, we'll stick with you on this one. And this is from Sylvia K. Thanks for watching on YouTube. Do we need to ask for employees to sign an acknowledgement of the policy? What's your take on that, Raquel?
There's no legal requirement to do that. It's good practice, right? It's a good HR practice to have evidence that somebody received the policy and so that they, right? Because they're allowed to go to complain to the ministry, say, I never got a policy. So it would be good to have a record that, yes, you did. This is when you got it. So, however you get that record, it may not be through a pen on paper sort of signature, might be a click box. Yes, I've read it. It might just be that they've opened the email. You might electronically monitor that they've opened the email.
Put that in the policy too, then.
Put that in the policy. But yeah, so for sure, you can certainly get an acknowledgement. I would follow what you do for all of your policies. What do you do for your harassment policies and so on and so forth? So
okay. And the distinction there, and I suspect it's a you're the lawyer, I'm not. It's a careful one. You're asking them to acknowledge receipt, not asking them to agree to the policy.
Exactly.
Is that okay?
Exactly.
Okay, we got that. We got a good question for Nagin here. This is Katarina Veilleux, and she got maybe a tricky one. We have offices in 3 provinces. Should the policy be for everyone or just Ontario employees? There's a good one, Nagin.
Yeah, that's a great question. And that's not something we covered, but an important point that we should cover. So employers that have multiple locations, if all the locations are in Ontario, all those employees would have to be covered, so long as they meet that 25 or more employee headcount. But it only applies to those locations in Ontario. So if those locations are outside of Ontario, there's no need to have the policy apply to them.
Okay. You just made me think of something. So if you have employees, let's say in Alberta or British Columbia, we're clear as far as we know, there's no legislative requirement, but I guess it's always a good thing to maybe have a policy like this. So, in Ontario, it would be a requirement, but in Alberta, you'd simply just want to be consistent across the company, not for legal reasons, but for management reasons. That might be an unfair question to ask you, Nagin. I don't know.
We would advise that they check in with local council to make sure that they're abiding by any sort of Alberta or Manitoba rules. But, I think it could be good practice to kind of create some consistency, but by no means are they required by the legislation to do so.
Gotcha. Okay. We're in overtime a little bit, but Raquel, we're going to have one last question, I think, unless another one comes in. Thank you to everyone for being so interactive. That's exactly what we want from these. And we're getting all sorts of thank yous, by the way, Nagin and Raquel, so people are very appreciative. But this last question is, so I suspect, from Judy Trudell, by the way, I suspect Judy might work in healthcare. Would electronic patient charting by personnel, e.g. hospital setting, need to be included? So that's interesting. Obviously not talking about the patient here, but a nurse, for example, that might be doing charting. And I guess if you're making a note in a chart, the person making the note, I presume, is being monitored to some degree. I don't know if you've got, that's probably a tricky one, Raquel.
It's not actually, because there's case law on this. So, right, the patient themselves have privacy rights that anybody in the hospital is not supposed to go searching around their neighbor's health records in the hospital, right? Oh, Fran's come in, I wonder what it's for. You're not, employees are not supposed to do that. So hospitals do track who has seen Francine's health records, right? Who's gone in and added a note to it, who's opened it up. And they do that because they have obligations under provincial privacy legislation. And so that monitoring of who's gone in to look at, to read, to open, to chart on patient records. So the monitoring of the employee, that for sure, that monitoring would have to be listed in the electronic monitoring policy.
Excellent. So it's very black and white. There's no gray, as I suggested. That's why you need to talk to the people even Harnden. So listen, we are going to start wrapping up. We're a few minutes into overtime. Thank you for so many people sticking around, both on YouTube and our other social media channels. Raquel and Nagin, great job. Obviously topical. Look at all the interactive questions we have. People very happy. But we should note that this, is a 30-minute show. We've covered a lot of territory, but every employment law issue is particular to that environment. So we highly, highly recommend that if you've got more questions, please reach out to Eamon Harnden. I know both Raquel and Nagin would be happy to speak with you. And with that, we'll bring your contact information on screen. So here you go, Raquel Chisholm and Nagin Yazdani. There's the contact info, very easy to find on the website too. You can look them up on the profile. So again, Raquel, thank you for being here.
Thank you for having us.
And Nagin, I hope I don't embarrass you. You were sharing a little anecdote how you watched some of these in law school, and now you're starring. It's your debut. It's your video debut here. So that's you did a great job, of course, and representative of lots of the young talent coming into Eamon Harnden and Nagin. So
thank you, Michael. Thanks so much.
Two thumbs up from Roger Ebert. So we'll bid you guys adieu, and we'll start wrapping up here. I want to remind everyone that you can visit obj.ca website each and every day. We have original content posted throughout the day. One of the really smart things, if you're a die-hard local business news junkie like I am, what you want to do is subscribe to OBJ Today. That's a weekday email newsletter. I know everybody has too many emails, but here's the pitch. You get one email, has all the headlines. You can scan it, and you can click in if you want more information. So I would suggest to you it's actually a very efficient way of keeping track of the daily news headlines. You can follow us on social media. A particular note, OBJ's LinkedIn has continued to expand and explode. I think we're approaching 27,000 followers right now. And if you're watching us today on YouTube, I'm going to ask you to hit the subscribe button. That number's going way up too. And there's another little bell icon right there. And if you hit the bell icon, the advantage is that you'll be notified on your smartphone or computer whenever we're live or post a new video. So it's a great way of monitoring content in a very passive way. So with that, on behalf of me, Hart and the Ottawa Business Journal, I want to thank you for watching. Please stay tuned for more great webinars coming up in the weeks. We're going to be talking of more technology. We're going to be talking to some post-secondary post-secondary institutions coming out. Lots of great content. So please stay tuned. And with that, I'll bid you adieu. Thanks for tuning in. Have a great day. Bye-bye.